Thank you, Mr. Rosenstein. I'll start by recognizing myself for questions. Last week, Director Wray indicated that the normal procedures were not followed in the investigation of former Secretary Clinton's email server. He said it was not normal protocol to have witnesses sit in the room during an interview of the target of an investigation. If the Inspector General determines that normal protocol was not followed or that the investigation was closed or otherwise tainted for political purposes, would that be a justification in your mind to reopen the investigation?
Mr. Chairman, we are certainly anticipating the outcome of that Inspector General investigation. As you know, that's been ongoing for some time. I'm hopeful that it'll be concluded within the next couple of months. And when we get those results, we'll take appropriate action. I don't know exactly what the findings are going to be, but it's always appropriate for us to review any findings of impropriety or misconduct and take appropriate action.
When you announced your decision to terminate the employment of FBI Director Comey, in that decision, you announced some practices that I took it to mean you thought were inappropriate actions on the part of the former FBI director. Do you think that those actions on his part would merit further investigation into how that whole matter was conducted?
Mr. Chairman, as you're aware, the Inspector General is conducting an investigation into the handling of that Hillary Clinton email investigation. And I believe that the matters that you've referred to are part of his investigation. The memo that you're familiar with that I provided reflects my personal opinion. It's not an official finding of misconduct. That's the Inspector General's job. He'll reach his own independent determination. But as you pointed out, my views about it are already known.
Are you aware of any prior efforts by the Judiciary Committee, this committee, to unduly restrict the ability of the intelligence community to do its job of protecting our national security?
I'm not personally aware of any, no, sir.
Are you aware that this committee has primary oversight of the Foreign Intelligence Surveillance Act due in part to the significant constitutional and legal questions that government surveillance raises?
Mr. Chairman, I respect the Congress's decision about which committee has oversight. I know that both this committee and the Intelligence Committee have an interest in that issue.
Well, given that you understand this committee's jurisdiction and its history of providing the intelligence community with the tools it needs, why would we, in the words of the department, attempt to, quote, dismantle Section 702 of our nation's most important surveillance program?
Well, I certainly would hope that wouldn't be the case. I don't know who made the statement you're referring to. I know the department obviously has expressed its opinion about the reauthorization, which we think is critically important of Section 702. I respect there are differences of opinion, but I think the department has been very clear that we believe it's essential to national security that Section 702 be reauthorized.
Well, we agree with you that it's essential that Section 702 be reauthorized. We also believe that it's essential that the civil liberties of American citizens be protected and that a standard be imposed on the examination of information about U.S. citizens incidentally gathered as a part of the Section 702 program with the surveillance of non-U.S. citizens outside the United States, but incidentally gathering information about U.S. citizens and then being looked into by agents of the Federal Bureau of Investigation without a warrant. I'm not aware of that being appropriate in any other type of investigation that they might conduct. And we're not talking about terrorist attacks. We're not talking about national security because we have clearly distinguished that. We're simply talking about crimes that have already occurred that are being investigated as they should be investigated by the department, but under the procedures that the American people would expect that they would follow to protect their civil liberties in other circumstances.
Mr. Chairman, as you know, I've had the advantage over the last 8 months of having a role in overseeing our national security operations. I discussed this with Director Wray yesterday, and if you'd like, I could give you a detailed explanation. It might take a couple of minutes, but I'd be happy to give you some details. But the bottom line is that it really is critical to national security that the FBI have the ability to query the data. That's the issue here.
And our legislation allows them to do that. But if the query provides a hit that they want to read an email, they want to see other documentation, they want to see in its full form, they're required to get a warrant under those circumstances.
And I discussed this with Director Wray, and what happens when the FBI conducts these queries, Mr. Chairman, is that typically they're leads that are not necessarily based on probable cause, but based on a lead, a suspicion, and the ability to query that data and then follow up on it gives the FBI the opportunity to put two and two together, to connect the dots.
There are lots of leads that any law enforcement person would like to pursue, but we have protections against them pursuing it without appropriate standard for doing it in a whole host of other ways to protect people from unreasonable searches. And this is a search of information about a United States citizen.
Well, it's a query as a constitutional matter. What we're
allow the initial query. Once that results in something the agent wants to look at, I don't see how you distinguish the further reading of emails or other things from a search.
If I could take a couple of minutes, I could explain to you, I talked with Director Wray about an appropriate way to explain this publicly. Hypothetically, let's say, for example, that local police department receives a call that somebody has purchased a large quantity of hydrogen peroxide, and something made the clerk at the store suspicious about that, so he contacts the local police. There's no probable cause. There's nothing illegal about what the person did, but something that caused concern. The local police may...
General Rosenstein, let me interrupt you, because the very specific instance that you are citing was cited to us in our discussions with the FBI, and that very specific protection for the FBI was added to our legislation.
Right. Well, the example I'm providing is a situation where there would not be probable cause, but we think it would be appropriate for the FBI to follow up. And what we're trying to avoid is a situation where we re-erect a wall that would prevent the FBI from gaining access to information that might allow them to connect a lead to information that implicates national security.
Thank you. My time has expired. Chair recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you. On Monday, Ranking Member Cummings and I wrote you a letter, sir, about the majority's ongoing investigation into the investigation of former Secretary Clinton. Without objection, I ask unanimous consent that our letter be placed into the record.
Without objection, it will be made a part of the record.
Thank you. For the first part of our letter discusses the department's failure to provide the minority with access to the documents you've already provided to the majority. Yes or no, will you commit to ensuring that the minority, that we receive equal access to any materials you may provide to this committee in the future?
Yes, and I believe my understanding is that that information may have been provided to the prior ranking member.
I'm not interested in the past at this point. Thank you. That's what I wanted. I have a lot of questions. The majority of this committee, the White House, and President Trump's private attorneys have all called for the Department of Justice to appoint a new special counsel to investigate a number of Hillary Clinton-related matters. I think we could benefit from your experience in how the special counsel regulations work. The regulations say the Attorney General, or in your case, the Acting Attorney General, will appoint the special counsel when you determine that 1, criminal investigation of a person or matter is warranted, and 2, the investigation either presents a conflict of interest to the department or some other strong public interest requires you to appoint the special counsel. That first part, when he or she determines that criminal investigation of a person or matter is warranted, is that part of the regulations optional?
No, that isn't part of the regulations.
Thank you. So a criminal investigation must first be determined to be warranted before you can assign a special counsel to the matter?
Yes.
Thank you. And at the Department of Justice, a criminal investigation requires an initial assessment and a preliminary review of the evidence?
Correct.
Has that assessment been made with respect to former Director Comey's handling of the Hillary Clinton investigation?
I'm not going to comment on any investigations in the normal course. Before we made a determination, we would conduct an appropriate review.
And I assume your answer would be the same if I asked you about the FBI's interaction with Fusion GPS?
Would be the same for anything, yes.
Then presuming for a moment that the department has conducted an initial assessment and found no predicate for a criminal investigation, so in plain English, there is no ongoing criminal investigation. Under this presumption, could you or the Attorney General Sessions simply appoint a special counsel to look into these matters?
No.
As I said earlier, to my knowledge, there's been no credible factual or legal claim that anybody at the department violated any law by deciding not to bring charges or by attempting to meet with Fusion GPS. If that is true, If there is no underlying criminal investigation because there is insufficient evidence of a crime, in this or any other case, do the regulations permit you to appoint a special counsel?
No.
Thank you. According to the Department, the Office of the Inspector General informed Special Counsel Muller of the existence of these text messages between Peter Strzok and Lisa Page on July 27, 2017. The text you sent us last night. Mr. Muller immediately concluded that Mr. Strzok could no longer participate in the investigation, and he was removed from the team the same day. Did Mr. Muller take appropriate action in this case?
Yes, he did.
Thank you. In testimony before the Senate Judiciary Committee, you said that you would only fire Special Counsel Mueller for good cause, and that you had not seen any yet. Several months have passed since then. Have you seen good cause to fire Special Counsel Mueller?
No.
Thank you. If you were ordered today to fire Mr. Mueller, what would you do?
So I've explained previously, I would follow the regulation. If there were good cause, I would act. If there were no good cause, I would not.
And you've seen no good cause so far?
Correct.
Thank you. On May 1st, the Office of Legal Counsel issued an opinion arguing that ranking minority members do not have the authority to conduct oversight, unquote. Shortly thereafter, Politico reported that the White House counsel instructed federal agencies not to cooperate with oversight requests from Democrats. Since then, Democrats on this committee have written more than 40 letters to the administration without any meaningful response thus far. Can you clarify your current position on responding to letters from the minority? And are you concerned that the Department's May 1st opinion serves to justify a policy of stonewalling by the administration?
My position, Congressman, is that we make every effort to respond to any legitimate inquiry from a member of Congress. Obviously, we prioritize inquiries propounded by the chair on behalf of the committee, but we'll make an effort to respond to any inquiry. We get a lot of letters.
I'm sure.
And so I apologize if there's a
delay. Would you
delay,
prioritize after letters from the chair, letters from the minority?
Our goal is to respond to all those letters in a reasonable manner. In fact, when our new Assistant Attorney General, Stephen Boyd, took office, there was quite a backlog.
And would you encourage the Office of Legal Counsel to withdraw its May 1st opinion?
I'll take a look at it, Congressman, but as I said, without regard to what the law may require, our policy is to try to
I understand that, but
requests.
you would take a look at whether you would encourage the Office of Legal Counsel to withdraw that May 1st opinion.
Well, I'm not committing to do anything. I will agree to look at it.
Okay, thank you. And finally, I just want to say and follow up with what the chairman was saying about Section 702. The bill that this committee reported specifically said where you're doing a counterintelligence or foreign or terrorism investigation, you don't need a warrant to query Section 702 data. But where you're conducting an investigation of domestic crimes, then, like any other investigation of domestic crimes, you would need a warrant. So that the danger that I think you were referring to is taken care of by the bill, and I endorse the comment of the chairman to that effect, and I think you should take a look at that. I urge you to take a look at that. Thank you. I yield back.